Hi, everyone, and welcome to the virtual legal clinic, Advanced Planning for the Broward LGBTQ plus community, where we will be having a lively chat about important legal documents to protect and prepare you and your loved ones. We will be discussing healthcare surrogates, living wills, financial power of attorneys, and estate planning. So wills and testaments, that sort of thing. A little bit about the organizations and people behind today's event. Legal Aid Service of Broward County and Coast to Coast Legal Aid of South Florida are Broward County's two nonprofit law firms that provide free legal services to eligible clients on a variety of civil legal issues. For a full list of services available at both programs, you can visit legalaid.org. Nova Southeastern University Shepherd Broad College of Law is our community partner for this event. NSU Law offers a cutting-edge, skills-centered academic program in 3-year full-time and 4-year part-time divisions. With its recently redeveloped clinical programs, every NSU law student is guaranteed a live client experience. In-house clinical studies are supplemented by full-time field placement opportunities, practicing law in Florida, across the United States, or select locations throughout the globe. To solidify student success after graduation, NSU Law pioneered a curriculum on the business of lawyering through the NSU Law Leadership Academy. NSU Law students have a myriad of curricular opportunities, including a rich, diverse curriculum, concentrations in international law, health law, or IP, technology, and cybersecurity, dual degree programs abroad in Rome, Barcelona, or Prague, dual degree programs at many of NSU's other 17 colleges, and much more. For more information, please visit law.nova.edu. The information today is brought to you by the Rainbow Justice Project, a program funded by a 2020 Broward Pride grant through the Community Foundation of Broward. A joint program of legal aid and Coast to Coast, the Rainbow Justice Project increases access to legal services for our LGBTQ plus neighbors by hosting virtual legal clinics with community partners and providing cultural competency trainings to our staff and to private attorneys that volunteer for the project. Behind the scenes today are the Rainbow Justice Project managers, Alicia Herwood, Chief Operations Officer, Coast to Coast Legal Aid, Kara Schakowsky, Supervising Attorney, Legal Aid Service of Broward County. Alicia and Kara will be monitoring Facebook and posting links and contact information in the chat. Now, because this is a program full of lawyers, we of course have to give some disclaimers before getting started. So the purpose of this clinic is to provide legal information on advanced planning matters. Specific legal advice will not be provided in order to protect attorney-client privilege. Presenters cannot see Facebook comments during the clinics, and questions are ones that were submitted in advance. So Alicia and Kara will keep an eye on the chat, and we will get to live questions if time permits. If you have a specific legal issue related to the matters discussed, please send an email to lgbtqsummit@legalaid.org. That's lgbtqsummit@legalaid.org, or call 954-736-2431 for screening of your legal issue. And when calling, please note that you are calling following the Rainbow Justice Clinic. This contact info will also be in the chat. Now I will tell you a little bit about myself. My name is Heather Lee O'Keefe. I will be your host today. I'm in my third and final year at Nova Southeastern University Shepherd Broad College of Law. I'm one of the youngest members in my class, and at NSU Law, I'm greatly involved as an executive board member of multiple student organizations. I'm the president of the Real Property, Probate, and Trust Law Society, vice president of the Transactional Law Practice Group. I'm on the elections committee for the Student Bar Association, and I'm also the director of social media for the Sports and Entertainment Law Society. And finally, the lead associate of LexisNexis on campus. So I stay very busy at school, but I also work part-time as a model and television personality, and also as a legal assistant to the managing partner of WFP Law, which is a boutique law firm in Fort Lauderdale that specializes in the areas of asset protection and estate planning. And our presenter, Ms. Jennifer Gomez Esquire, also works at WFP Law with me. So I will let her give a brief introduction of herself now.
Thank you for all of that. It's definitely a lot of stuff to cover there initially. My name is Jennifer Gomez. I'm an estate planning attorney. I've been practicing in trusts and estates for over a decade, and this has always been my passion, the work that I really enjoy doing, because most of it centers around preventative work. So helping people that want to be proactive, make sure that they have plans in place to keep themselves safe, to make sure that their family is safe and protected. And so I try to take as much time as I can, both to volunteer as a pro bono attorney through legal aid to make sure that the clients that they serve are getting good service, but also to help out with some of these different clinics and seminars to make sure that the public's getting good information. Unfortunately, a lot of people learn about these topics from stories that they hear from friends and family who may live in different states with different rules, or something they saw on Netflix. And so I think it's really important for attorneys, if they're able, to make sure that the right information gets out there so people can make good decisions. We'll also help you guys learn how to get in touch with legal aid, or if you do decide to hire a private attorney after listening to some of the information we're going to go over today, you'll be able to get the most out of that investment that you make with a private attorney.
Absolutely. So without further ado, we are going to go ahead and get started with our question and answer session. And we'll begin with Jennifer. What are advanced directives and who needs them?
So just kind of like that name sounds, advanced directives let you give directions in advance for what should happen in your life if you're not able to take care of things for yourself. So this would be in a period of time where you're incapacitated, meaning you can't make your own health or financial decisions, usually related to some sort of healthcare issue like a serious stroke or dementia, or even on a temporary basis for something like you're unconscious because of a surgery that you need, or some sort of other health issue that might be, short or long in duration. So these are plans that we put together with legal documents that give them their power, and it's going to let people choose who should be making decisions for them, and also in some cases is going to let the client give an outline for how they want certain situations handled. So it's really important for any adult who's over 18 and has capacity now to put these plans together in place so that if something does arise down the road, they've got everything set up so their life can kind of function how they best hope it would.
So advanced directives include things like powers of attorney. Can you kind of explain what that is?
Yeah, a power of attorney is a legal document that primarily is going to talk about financial issues. So financial, business, banking, different things in that realm. It lets you choose someone who you trust to make those kind of decisions when you're unable. So it can be very specific and get down to the nitty gritty of different types of bank accounts or real estate transactions or lending, but it also is usually going to cover more broadly, a catch-all provision for and anything else that might come across in financial aspects. So, it's a really important planning tool. Even if you don't think of yourself as someone who has money, it still covers things like changing your insurance, forwarding mail, applying for government benefits on your behalf. So it's something, even if you don't have assets or a ton of wealth that you think of, you still have aspects of your life that are financial in nature to cover.
So we had a question. Does the person chosen to be your power of attorney need to be an actual attorney?
I've had that question many times before, and no, it doesn't have to be an attorney. I always recommend that it's someone that that you can trust to make good decisions, and someone who's reasonably organized. So obviously kind of makes sense if someone's going to be taking over your finances for you. You want someone who's good at, keeping records, following the instructions of a CPA if needed, and that sort of thing. So they don't have to have a law degree. It's just sort of an old-fashioned term of art that we use.
So who should someone choose? Should it be like a family member? Does it need to be a family member?
Doesn't have to be a family member, although that's a very popular option for someone. Usually spouses tend to name each other for these kind of roles, but I also see lots of parents naming their adult children to serve as their power of attorney agent, but it can also be your friend, a life partner. There's really no limitation to who you can name. You can even, if you don't have someone that you know personally, you can name a professional to serve as a fiduciary. And a fiduciary is really just any kind of decision-making person in one of those trusted positions. So a lot of people, if they have great idiots, they might be in a, more of a position to name a professional fiduciary that way they know everything's going to be handled by the book and in a very organized format.
Great. So we were just talking about financial decisions. Now let's move on to healthcare decisions. What is a healthcare surrogate and what kind of decisions do they make?
Healthcare surrogate, like you said, switching over to the healthcare aspects of things, they're going to take care of healthcare decision making for you. So anything you would normally decide for yourself in that realm, whether that's if you should be taking a certain medication or not, if you should have a certain medical procedure or not, all of those kind of things that you would normally be deciding in conjunction with your medical professionals, your healthcare surrogate is the person that you've chosen to make those decisions for you. And you can actually have different people serving in both of those roles. So you may have one family member who's really well suited towards financial decisions and another one who's much more suited towards healthcare planning and decisions related to that. So it doesn't have to be the same people, but it certainly can be if that's what makes sense for you.
Great. You already answered my next question, is who should someone choose for that? So we will move on to the next question of what is a living will?
So a living will is a healthcare planning document, and it basically talks about how you want things handled as far as end of life decisions. So this would be stating in advance that you wouldn't want to be kept on artificial life support if there's no medical probability of recovery. So it's a very important planning tool for a lot of people who don't want to put that burden on their healthcare surrogate. Certainly they're choosing someone who knows them well, hopefully, to make healthcare decisions for them, and that person may know how they feel about life support, but it can be a bit of a guilt-ridden decision to actually decide to remove life support. So for a lot of people, even if they are naming a close family member, they'll decide to still have that living will in addition so that they've stated very clearly what their wishes are.
Now, is this different from a DNR, like a do not resuscitate, or a last will and testament?
Mm-hmm. Yep, very different from both of those. So it's similar to a DNR, a do not resuscitate order, in that they're both talking about different medical treatments and things that can happen to keep someone alive. But a do not resuscitate order is basically saying, don't try those things in the first place. Whereas a living will is saying, if you tried artificial respiration or something like that, to go ahead and remove it if it doesn't seem that that's going to be helpful. So typically someone who's in good health might have a living will, but a DNR is more commonly used by someone who's already had some serious health issues or maybe advanced age, other, just things in their life and their health that would lead them more towards deciding against having some of that treatment that can have some side effects or consequences as well. So it's more common, let's say, for a client who already has dementia or already has advanced cancer. They don't want to go through some of that additional medical treatment if it's not likely to be helpful for them in their situation. And then as far as different from the last will and testament, definitely get a lot of people with those things confused because living will, last will sound similar. But a last will and testament is really what talks about how your assets transfer at your death. Whereas a living will, it's more like the last decision that happens in your life. So one's totally in the healthcare realm. The other one's really more has to do with your own personal finances, and can also name guardians for children if you have them. So if a parent dies while their kids are still young, the will or even some other planning tools that we use can, help set up guardians and have some plans in place for those children to make sure that they're going to be well cared for as well.
These are all really important things. I think everyone needs these. So my next question is, how can someone create an advanced directive?
Great question. So definitely want to make sure that it's clear that today isn't a how to set these documents up. Certainly, I always advocate that someone uses an attorney to help them set up any kind of legal documents. So whether that's estate planning or businesses or contracts or, real estate sales, it's always good to have someone look it over that has that training to make sure that it's going to have all of the right intended consequences. There are some things that are probably easier for someone to handle than others. Here in Florida, we have a statutory form for both the healthcare surrogate designation and the living will. So that means if you actually go to the Florida statutes and look, there's a format in there that's designed to be simple enough that someone could do it themselves. So certainly you don't want to vary from that form if you're going to be relying on it. But even still, I always recommend someone consult with an attorney, and definitely if they're going to be doing anything that's more complicated, like the power of attorney or will, those kind of things, you should either contact legal aid, get an attorney through there, or you can contact your local bar association, find an attorney in your area. But you certainly don't want to do these things alone, because in a lot of cases, you won't find out that there's an issue until it's too late. So it's something where these documents don't really come into place until after someone's passed away or after someone's having a medical issue, and then it can be a lot more difficult at that time to go ahead and get things cleared up.
Great point. I say it's always better to be proactive than reactive. I know a lot of people are scared of maybe reaching out to an attorney. They don't want to face the idea of something bad possibly happening to them one day. So could you maybe explain the process of someone calls you and they want to set up a consultation? Where does it go from there?
Yeah, absolutely. And I think a lot of people have this sort of image in their head that an attorney or a law firm is kind of this stuffy, nerve-wracking, formal experience. And it can be in some situations. But I definitely know our office is super friendly and laid back, and most of us have really personal relationships with our clients. We know them well. It's definitely a place where if a client wants to show up in shorts and flip-flops, that's fine too. So I think a lot of people may be hesitant to reach out to an attorney because they think that it's, going to be a lot more like what they've seen on TV. But particularly with estate planning, it's so personal in nature that I think we tend to be a little bit more of the warm and fuzzy attorneys. So usually the process would start with someone calling into our office. We would get some initial information from them just to make sure that they're a right fit, help them kind of prepare a little bit in advance what sort of things they might want to think about as far as who they want as their decision makers, so that they can either discuss that amongst themselves if it's a married couple coming in to do planning together, or just have some time to maybe confer with the people that they want to appoint as their fiduciaries. From there, we would either set up, a consultation over Zoom or phone or in person, and then we get to design out the plan a lot more thoroughly. So then it's on to the lawyers and staff to go ahead and get everything drafted and have the client sign their paperwork. So really the getting up the confidence to call, make that appointment and come in, that's the hardest part. From there, we kind of take over and do all of the strategy, making sure that everything's going to be, as easy as possible and make sure that it works well in line with their goals.
And our next question, I know some of these documents need a notary to be correctly completed. Is that correct?
Yes. So I tend to be of the very cautious side where I have two witnesses and a notary on everything for the most part, just because one, it streamlines the signing process. If we're signing a bunch of legal documents, it's easy to just have it consistent across the board. So I would always say probably better to have too many witnesses or notaries than not enough. You can sign a living will with just two witnesses. You don't need to have a notary on that. Same with the healthcare surrogate. You don't need to have a notary on that, but you can have a notary sign them with you if you want. Certainly not going to cause any harm there. And, sometimes it may be difficult to find witnesses years later that signed a document. So I always say better too many than not enough.
Very good point. So someone comes to you, they set up these documents, a few years pass by and they want to make changes. Can you update these documents, and how do you go about updating them?
Mm-hmm. Yeah, absolutely. All the things that we've been talking about so far today, they aren't set in stone. So as long as the client still has capacity to go ahead and update the documents, they can do that. And, it frequently happens if a client has, a change in their life, like they get married or, some of their children are getting older. Maybe they want to have them more involved in the planning. Those are a lot of really common reasons to make a little update here or there. So the option's pretty much always available to go ahead and update it. But I do always tell people to be very cautious about how you update it. In most cases, we're just going to do a fresh legal document, have new witnesses and notaries signing with everything, because I have seen some people try to, just write in some changes into a document that's already been signed. And that's probably not going to have any legal weight to it, because we have those formalities for executing documents for a reason. So it's harder for, a court or anyone to understand, who wrote that in there, if there are no witnesses with it, no notary. So a lot of times those things that people will try to add into their legal documents afterward are actually not going to have any impact at all. And, if a will has a little handwritten addition, and even sometimes a handwritten addition maybe with one witness or one notary or something that someone wanted to try to make it a little bit more formal, it's pretty much as good as doing nothing at all. So always make sure, if you're going to try to update legal documents, that you do that with an attorney. Make sure that you're following the same formalities, that you need to sign a fresh document. That way you don't have anything where you're thinking you're covered or think you made a change, but maybe it's not going to have that same legal weight that you want it to.
Another important reason to consult an attorney. We can't stress that enough. So now, worst case scenario, what happens if the person that someone listed on these documents can't serve? Can they list a backup, or what happens then?
Yeah, absolutely. It's always recommended to have backups in place. I usually tell people you can list as many good, trustworthy people as you have in your life. We can make the list as long as you want. And it's important for different situations. So if the person that was your first preference, maybe they predeceased you, or maybe they have something going on in their life at that point in time where they're not able to take the time to serve in that role, or maybe they've got their own health issues going on and they don't have the capacity to serve in that role. We certainly don't force anyone to do work that they don't want to. So if for any of those kind of reasons that person can't serve, we can go to whoever is listed as the backups. But there are definitely times where, through luck of the draw or whatever it may be, a person will run out of backups on that list. And then we basically are in the same place as if we'd done no documents at all, because if we have a power of attorney document, as an example, that's so that we don't have to go through guardianship court. That's avoiding the need to have a court supervise what happens with your finances. And if you run out of people that were listed on that power of attorney document, then we have no one to serve in that role. And then we still would have to go petition the court for guardianship and have a guardian supervising the finances and property. So, not to say that anyone should list a backup who wouldn't be good in that position, but, if you've got a good handful of people, it's certainly easy enough to add a few extra names onto the list and make sure that those documents are going to last over time.
Great. So far we've discussed powers of attorney, healthcare surrogates, living wills. What are some other legal plans that someone should consider in addition to advanced directives?
Yeah. So advanced directives, I think, a lot of times I'll refer to those as like the bachelorette plans, because those are sort of the bare minimum that any adult needs, because it's what covers them personally. So it's making sure that their life is going to be okay, even if they're not able to be in charge of it. There's a lot of other aspects that go into an estate plan that may benefit the client themselves, but they also tend to benefit other people as well. So a lot of that may be things like a will or a trust. Both of those are a set of instructions for what happens to your assets at your death, or with a trust, it can both control during your life and after your death. The difference between a will and trust being the will needs to go through the probate court at your death to be processed there. So it's a little bit more of a lengthy, formal, and a bit more of an expensive process. But, in either case, whether someone has a will or a trust-based plan, they're able to choose who's in charge of managing things, who should receive an inheritance, whether that's friends, family, charities, and then they can also put in instructions for how those people receive those assets. So whether one of the beneficiaries is a young child who may need some help with managing their inheritance, or maybe a beneficiary with special needs who would benefit from having a trustee in place to manage that inheritance and make sure that it's going to last and used properly, and also not jeopardize any government benefits that that person may be receiving. For clients that have young children, I already touched on it, but it's very important that they name guardians for those minor children. So I tell people all the time, it's probably the important paragraph in their entire estate plan if they have children, is getting good guardians in place, because there's no amount of money that can make up for having bad backup parents. So, I think it's something that should be really carefully thought out by that child's parents, rather than just kind of leaving it up to a court where there may be a lot of people that want to become the guardian of that child, and they may have mixed reasons for wanting to do so. So definitely a really important aspect of planning.
Can you explain maybe some of the downfalls that could happen if you pass away without having created a will beforehand?
Yeah, in Florida, we have some rules for how we handle estates if someone dies without a will or a trust or other instructions. We call that dying intestate, without a will. In that kind of a scenario, you're trying to fit everyone into this one very kind of heteronormative, very specific framework. And so that might not match up at all with what a person would have put together if they'd actually taken some action and made a plan. And it kind of goes along a lot of the logical family tree sort of lines where, a spouse may have preference for being in charge of things, or, children would be more likely to inherit than more distant family members. But for someone that has a blended family or a non-traditional family, that scheme may be totally different than the people that are actually important in their life. So I think for everyone, it's really important to have plans where you're articulating all of this. But if your life is anything different than that really kind of basic traditional family layout, it's even more important because it might end up having people that you really don't want in charge of things, in charge of all sorts of aspects of your life.
And we have a next question. It's a very simple one for you. Someone wants to know, what is a will? What does it look like? What does it entail? Just what is a will?
Yeah, so the will is really the legal document itself. So I like to think of the estate plan as sort of the concept and the strategy, whereas the actual legal documents are where we write all of this out, have all of the instructions, and written in a way that it's going to be very easy for a court to interpret what you meant. So that's a lot of what an attorney does to really help a client, is make sure that the way that they articulate their goals is going to be very clear, very precise, very organized, so that those things are what ends up resulting at the end of the day. So the will can be short in length, it could be longer, but it's going to have a lot of those different provisions in there that we talked about. But it's kind of just putting these plans on paper for what you actually want to see happen.
Next question, very similar. Just simply put, what is a trust?
Yep. So that's the legal document for that slightly more advanced planning than a will. So like I said, they're similar in that they're both sets of instructions listing certain people in charge of managing your affairs. The trust-based plans can be handled privately, which is a big advantage for a lot of families for a number of different reasons. So trust can be handled privately, which cuts down a lot of the costs because we don't need to get the court as involved. So you're saving on court filing fees, you're saving on attorney fees. It's also tends to be a lot quicker to administer a trust than a will. So if your assets include a home or a business, some of those kind of things, that the sooner you can sell it, the more money you're probably going to get for selling it. And you're also going to avoid some of those maintenance costs in the meantime. So if you have a home that has to go through the entire probate process over the course of several months, or in a contentious situation several years, someone's paying all of those bills in the meantime, or they're just stacking up. So a trust can be really advantageous for families that own real estate or businesses. Those are definitely things where I would tell someone that they really need to get with an attorney and make sure that they have some kind of planning in place to keep it out of the court process. And also it keeps things private, which a lot of people may not care one way or another if their will becomes a public court document. But I think in most cases, people would rather kind of keep those family matters private and not potentially have their children or other beneficiaries become potentially victims to financial predators that then see that someone's receiving an inheritance. So all good reasons to at least consider whether you need that kind of advanced planning as well.
You mentioned businesses a little bit. Can you explain what a business entity is and how it could be helpful in the estate planning process?
Mm-hmm. Business entities is really kind of a general term for all of those things like a corporation, a limited liability company, a partnership. So that's how we typically structure businesses. So if you look up the records for Walmart or Target or whoever, they have some sort of business entity structure, or multiple entities probably. Families can use it both for small businesses or even potentially for liability protection for things like rental properties. So again, we're getting into a little bit more advanced planning there, but it's something where you should at least be aware if you're operating a small business or if you have a rental property or some other investment real estate, that should clue you into knowing that you need to have a conversation about adding some additional things into your planning, or certainly at least considering them.
Great. So now, do same-sex couples need special legal planning?
So I would say the answer is yes and no to that. I think the recommendations that I make for same-sex couples tend to be the same recommendations that I make for married couples. So we'll usually have a conversation with the couple and see how they want things set up. Usually they're putting each other in those trusted roles, and we want to make sure that we have legal documents in place that prove that. Because although a spouse may be the preferred person for a lot of these things, it's not necessarily a guarantee that your spouse would be the person that a court chooses to act on your behalf. It's important to think about, some of the famous cases that we've had here in Florida with how the courts have treated things like healthcare decision making. There's a famous case from a few years back about Terry Schiavo. For her parents were trying to make different healthcare decisions for her than her husband, and they ended up having to fight it out all the way to the state Supreme Court. And, that's something where I think a lot of people make the assumption that your spouse, in absence of other documents, would just be the person who makes healthcare decisions for you. But that was, a prime example of why it's really important to have these legal documents in place, even if you're married. So I recommend the plans for same-sex couples and opposite-sex couples, but with the caveat that for an opposite-sex couple, it's probably going to be a little more likely that someone will give you a hard time at some point or another, whether it's a bank or a hospital or something like that. I think the probability that something happens is greater, so it's more important to get those plans in place. And also, again, like we said, with the default rules in Florida, they tend to be a little bit more different. So the desired result versus the actual result may be more dramatically different for an opposite sex couple. There's a lot of stuff that people are talking about right now with potentially the changing composition of the United States Supreme Court and how that's going to impact people who are legally married now. So I think also in that kind of a scenario, if there's a married couple that's been relying on that for some of these default rules, it's even more important than it's ever been that they go ahead and get the legal documents in place to back that up in case the law around that changes. I've also seen some people talking about whether or not they preemptively want to go ahead and get married now while same-sex marriage is legal to potentially get grandfathered into some of those protections. And my advice there is, if you weren't planning to get married anyway, there's probably time to wait and see how the courts are looking at that. Usually something that gets all the way up to the United States Supreme Court, it takes a long process of going through the lower court system first. So it's something to certainly keep mindful on. We don't know how it's going to get decided or when or what exactly may come from that. But it's important to stay informed and on top of issues that might be impacting your life or your finances or your marriage.
Great. Thank you, Jennifer. That brings us to the end of the questions that were sent in ahead of time from members of the community. We do have a few extra moments left for a few live questions. If anyone wants to put them in the comments section on Facebook, the moderator will screen them and send them our way if they're appropriate. Remember, specific legal advice will not be provided just in order to protect that attorney-client privilege. But we do have some time left for any live questions. If you have those, send them our way in the comment box below. I've also been asked to remind you that there's a link in the Facebook comment section for the YouTube playlist on all Rainbow Justice virtual clinics. So you can go there and view past clinics. I'm sure this one will be on there. If you joined us in the middle of this and want to watch what we had mentioned before you logged on, you can view that there and view some of the other videos that they have posted. And also, we would like to invite you to watch Coast to Coast Legal Aid's Facebook page tomorrow at 2 p.m., same time, for another Facebook Live Q&A on a CDC housing moratorium. So moderators, do we have any questions coming in? Unfortunately, we can't see Facebook, guys. So, we see the Facebook, so they're gonna send stuff our way if you send it.
And I'll just take this as a moment to remind anyone who's listening, if you are concerned with the cost of setting up these legal plans, Legal Aid is a great resource. In a lot of cases, they refer out to private attorneys who will handle estate plans on a completely volunteer basis. So, a lot of attorneys like myself, our firm will take, a number of cases every year to try to make sure that as many people that want to be proactive can get these plans set up. So, you're still going to get that same level of service that if you come in as a paying client. And, again, it's really hard to know what you don't know. So trying to set some of these things up on your own, you may have a surface level of understanding of what needs to be done, but you may not know how little intricacies in your life might change those plans. And so if you don't know, then the chances are that the plan isn't going to work out in exactly the way that you'd hoped it does. So definitely don't go it alone.
Great advice. And just a reminder, to sign up to meet with an attorney to complete the documents discussed today, please send an email to lgbtqsummit@legalaid.org or call the hotline at 954-736-2431 and mention Rainbow Justice. These will be in the comments if you didn't have the chance to write that down. And also, if you have comments on today's clinic or suggestions for topics we should feature next, please take the quick survey that will be linked in the comment section as well. And also, we want to give a huge thank you to the Community Foundation of Broward, who fund the Rainbow Justice Project. And without those, we wouldn't be able, or without their support, we wouldn't be, without their support, this program wouldn't exist. And also our fantastic community partner, NSU Law, and student volunteers for keeping things lively. Very special thank you to our estate planning attorney, Jennifer Gomez, who took the time out of her undoubtedly busy schedule to join us today and share her knowledge and experiences. Please follow us all on social media, all of the agencies you heard from today, so you can stay updated on all of the most up-to-date info, activities, and events. And finally, thank you again to everyone who joined us today. Please stay well and have a wonderful day. Thank you again.
Thank you.